So, a very warm welcome to all of you joining us today on our People Matter webinar, which is on dealing with statutory holiday entitlement. Just by way of introduction, my name's Emma Pattenden. I'm a Principal Associate in the Employment, Pensions and Immigration team here at Mills and Reeve. I'm joined today by my colleague Abizola Latunji-Kobil, who's also a Principal Associate in the team. Just before we get underway, there are a couple of housekeeping points that I wanted to cover off. So today's session will be recorded and the recording will be made available afterwards through our Mills and Reeve website. You should all be able to see a Q&A box, which will open up from the bottom of your screens. Today's session is scheduled for about half an hour, but we're hoping we'll have some time towards the end of the session to look at some of your questions. So do feel free to pop your questions into the Q&A as we're going along, and then we'll have a look at them at the end. Also, at the end of the session, a feedback form will pop up on your screens, and we'd be very grateful if you could complete the feedback for us. That really helps us. So, what are we going to cover today? Well, I've set out on the slide there the topics that we're going to be moving through. So we're going to start with basic reminder around calculating holiday pay. We'll look at accrual during periods of leave, in particular statutory and sick leave. Abizola is going to look at the new rules around atypical workers and whether or not to roll up holiday pay for those workers. And we'll also look at dealing with backdated claims and any limits that there are in terms of how far back workers can claim for holiday pay. So first of all, I'm going to look at calculating holiday pay. And just a reminder around the basics around that. So holiday pay has obviously been a topic of some interest in the last 12 months or so. And we saw some changes in the rules for regular workers from the 1st of January this year. The government passed a new law which effectively writes EU case law on holiday pay into UK legislation to ensure that the law is preserved post-Brexit. So it's basically a restatement of the law that already existed. So I've set out on the slide there that for normal workers, so workers who aren't irregular hours or part-year workers, there are still two distinct pots of annual leave with two different rates of pay. There was an opportunity to amalgamate the two types of leave, but that isn't what happened. So that distinction does remain going forwards at present. So we have 4 weeks of EU leave, which needs to be paid in accordance with a new definition of normal pay. And then the 1.6 weeks of extra UK leave on top of that, which can still be paid at basic pay. These rules and the other rules will be modified for atypical workers where their holiday year begins on or after the 1st of April this year, and Abizola will cover that later on in the talk. So moving on to the new definition of normal pay. What is normal pay? Well, there's some new government guidance to accompany the changes to the working time regulations, which talks about the concept of normal pay. And the intention is to help clarify the rules, but I must say that in some areas it's raised more questions than it's answered, perhaps. The guidance tells us what elements of a worker's pay must be included in the 4 weeks of normal holiday pay. So that's the holiday leave derived from EU law, from the Working Time Directive. The regulations themselves don't use the term normal pay, but they list what should be included for the purposes of calculating a week's pay, as I've set out on the slide there. So this includes commission payments intrinsically linked to the performance of tasks which a worker's contractually obliged to carry out, payments for professional or personal status, and payments such as overtime payments, which have been regularly paid to a worker in the previous 52 weeks. So there's a reference period there that's used of the 52 weeks prior to the leave being taken. I should say many employers choose not to distinguish between the two pots of leave and pay the entire 5.6 weeks at the normal rate of pay. So they'd include all of these elements anyway, just because it's administratively easier. And as I've said, the distinction won't apply to atypical workers under the new rules. There's still a fair bit of uncertainty around the definition of normal pay, and there is some ambiguity, and this is in part due to the fact that there are some gaps in the underlying case law and still a few grey areas. So, for example, the calculation of normal pay could catch some bonuses and some allowances, for example, car allowances, if they fall within one of the three categories there on the slide. Much will depend upon the nature of the bonus or the allowance. So there's likely to be some further case law in this area. Moving on to accrual during periods of leave. The new regulations include an express requirement for annual leave to be carried over into a subsequent leave year in certain circumstances. So including where the worker is absent on sick leave or statutory leave, or is denied his or her paid leave entitlement. The rules for atypical workers are slightly different, and Abizola will talk about that a little bit later. So employees continue to accrue or build up holiday while they're on statutory leave. So, for example, maternity or paternity or parental leave. And during periods of family leave, they're entitled to carry forward 5.6 weeks holiday, and this must be taken by the end of the following leave year. So if a short period of leave is taken, for example, 2 weeks of statutory paternity leave, then there are likely to be sufficient opportunities to take holiday throughout the rest of the year. But if someone's off for a longer period, for example, 52 weeks of maternity leave, then there's likely to be a need to consider carryover. And it's normal for employers to have a conversation about that with a worker who's due to go on leave, to explain how much paid holiday they'll accrue during the planned leave, when they'll take it, and how much they can carry over if that's appropriate. Similarly, workers accrue holiday when they're off work because of sickness or injury. Employers may have different rules on how they pay for holiday and sick leave, so it's a good idea to check the employment contract and any relevant policies. But the legal position is that if someone is not able to use their holiday because they've been on long-term sick leave, then they can carry it over. As I've said on the slide there, during long-term sick leave, workers are entitled to carry forward 4 weeks holiday, so not the full 5.6 weeks, but the 4 weeks holiday, although individual employers may allow more to be carried over. They don't have to prove that they couldn't take the holiday, just that they were ill, and the leave must be taken within 18 months of the end of the leave year in which it was accrued. I just wanted to highlight briefly some other situations where accrual may apply. So if an employer fails to recognise a worker's right to paid holiday, or fails to give them a reasonable opportunity to take the leave or encourage them to do so, or fails to warn them of the risks of losing their holiday at the end of the leave year, then in these circumstances, they can carry forward a maximum of 4 weeks holiday entitlement. In these cases, the right to take the carried over leave will last until the end of the first full leave year in which there's no such failure by the employer. And it's obviously important for employers to have systems in place that allow them to track this holiday over time. How would you encourage employees to take holiday? Well, I've set some suggestions out on the slide there. So it's obviously important to have a clear holiday policy, making clear that any leave not taken within the relevant leave year will be lost. Ensure that managers are trained so that everyone understands the requirements. Having reminders through line management actions, such as in meetings and through one-to-ones, perhaps sending out email reminders, perhaps towards the end of the leave year, reminding workers as to how much leave they still have to take, and that it will be lost if it's not used before the end of the leave year. You could also incorporate notifications into holiday booking systems themselves. Obviously, making sure that there are plans in place to cover any absences, and just promoting a general culture of well-being within the workplace to ensure that people understand that they need to use their leave in full. I'm now going to hand over to Abizola, who's going to talk us through the new rules for atypical workers.
Thanks, Emma. So Emma has very helpfully explained how the changes to the legislation apply to what we've referred to as normal workers. And I'm going to spend a bit of time now looking at an entirely new system that the new legislation has introduced in relation to what I'm going to refer to as atypical workers. The first point we need to look at here is what do we mean, or what am I referring to when I refer to atypical workers? And the legislation categorizes two different types of atypical workers for these purposes, as you'll see on the slide. The first category are irregular hours workers, and those workers where the number of hours that they work in each pay period is wholly or mostly variable. And when I refer to a pay period, what we're talking about there is the frequency with which a worker is paid. So if they're paid on a monthly basis, for example, a pay period will be a month. If they're paid on a weekly basis, a pay period will be a week. Now, what we don't have, somewhat unhelpfully, within the legislation is a definition as to what is meant by wholly or mostly variable. So you can imagine some circumstances where there may be scope for dispute as to what that means, and ultimately that would be something that would need to be determined by an employment tribunal. But in reality, really what we're talking about here are the sorts of arrangements that I've put on the slide, so 0 hours contracts, casual contracts, bank workers, and those sorts of arrangements. The other type of atypical working, which is covered by the new legislation, is in relation to part-year workers. And those are workers where they've got a contract in place for a period of time during the leave year, whether that be for the entirety of the leave year or part of it. But importantly, they need to be required to only work for part of the leave year. And notwithstanding that, there should be part of their contract where they're under contract, but they're not required to work and during which they don't get paid. So what we're looking at there are typically seasonal workers, term time only contracts. There was initially a bit of dispute as to whether or not annualized hours contracts came within that definition. The first version of the government guidance seemed to indicate that they wouldn't, because whilst they don't work for the entirety of the year, they do tend to get paid throughout the year on a regular basis. But the most recent iteration of the government guidance seems to indicate that they are included within that definition, which is helpful to note. So just to bring that to life with a couple of examples that are in the government guidance. So let's say that Kevin is a hospitality worker who works a different number of hours each week. So if his contract provided that he was paid on a weekly basis, for example, so his pay period is a week, and the number of hours that he's required to work each week is wholly or mostly variable, then he would be an irregular hours worker for the purposes of the new legislation. So he might be on a 0 hours contract, for example. If Melanie is a seasonal worker in the farming industry who only works and gets paid in the spring and summer months, and she has a contract which is in place for example, the entirety of the leave year, she doesn't work in autumn and winter, she's not required to work during those months, and she's not paid during those months, then she would be a part-year worker for the purposes of the new legislation. Just to contrast that a little bit, let's take the example of Paul, who has a rotating 2-week shift pattern, working 15 hours one week and 20 hours in the next, and he doesn't work any overtime. Whilst your initial thought might be that he's a variable hours worker for the purposes of the legislation, actually, because his shift pattern is set, notwithstanding that it changes from week 1 to week 2, he wouldn't be an irregular hours worker for the purposes of the legislation. So now that we know who we're talking about, and as I say, I'm going to refer to them as atypical workers in this section, what are the new rules that apply to these workers? There are 4 areas that I'm going to look at, which you'll see on the slide. But the first point that an employer will need to consider is when these new rules apply to its organisation, because that varies depending on when your holiday year starts. So as it says on the slide, the new rules apply to holiday year starting on or after the 1st of April this year. So in practice, what that means is that if your holiday year started on the 1st of June this year, then these new rules have applied to you as of that date. In contrast, if your holiday year runs from the 1st of January to 31st of December, then the new rules won't apply to your organisation until the 1st of January next year. So you've got a little bit of time to get up to speed with the changes. So let's have a look at accrual of holiday first. And many of you will remember the case of Harper Trust and Brazell from 2022. And I'm not going to go into the facts of that case for these purposes, but you'll remember that it related to a term time only contract. And the effect of that case was that it was decided that for a part-year worker, like someone on a term time only contract, their accrual of holiday was such that they might be entitled to a significantly greater amount of holiday than a part-time worker who works the same number of hours, but they work them regularly throughout the year. And that was quite a surprising decision to certainly a lot of employment lawyers and also a lot of employers as well. So what the new legislation does is to reverse that decision by providing for a statutory basis for holiday to accrue for atypical workers. So the position is now that on the last day of any pay period, so as I say, that might be a month if your workers are paid monthly. So on the last day of that pay period, your atypical worker will accrue holiday at the rate of 12.07% of the hours worked during that pay period. So what that means is that you've got a set way of calculating how holiday accrues for your atypical workers. It's now calculated in hours rather than weeks as it is for traditional workers. And you'll also likely know that the 12.07% figure is intended to represent the 5.6 weeks entitlement that normal workers get. So of course, if you're wanting to offer atypical workers an entitlement that's greater than that, then that percentage will need to be adjusted accordingly. There's an exception when that accrual rate isn't applied, and that's when your atypical worker is on sick leave or some form of statutory leave, such as maternity leave. And in those cases, holiday accrues at a rate of 12.07%, but based on the number of hours worked during a 52-week reference period. And as it says on the slide there, if someone's holiday entitlement, once you've calculated it, includes part of an hour, if that's under 30 minutes, then that's rounded down to 0. If that's 30 minutes or more, then that's rounded up. So we've now got a clear system for calculating the accrual of holiday for atypical workers. Looking next at the calculation of holiday pay for atypical workers. And what I'll say at the outset is that an employer now has a choice as to how it pays holiday pay for atypical workers. They can either deal with it by way of rolled up holiday pay, which I'll come on to a bit later, or they can pay the holiday at the time that the worker takes the holiday. So typically in the same way that you would for normal workers. It says on the slide there how you calculate that, and it's thankfully fairly straightforward. So you would need to calculate a week's pay using normal principles, so including the various elements that Emma spoke about earlier. You'd calculate that over a 52-week reference period. You then calculate the average number of hours worked per week in that same reference period and divide the weekly pay by the average number of hours worked, and that gives you the amount of holiday pay. So as I say, thankfully fairly straightforward. The next area dealt with by the new legislation is in relation to the carryover of holiday. And again, Emma's already spoken about the rules in relation to carryover of holiday for normal workers. And the same circumstances are replicated for atypical workers as to the fact that you carry over annual leave that you weren't able to take during long-term sick leave, family-related leave such as maternity leave, or if the employer doesn't allow the worker to take their holiday. There is an important distinction here, though, which is that, as Emma mentioned, in circumstances of long-term sick leave or the employer failing to allow the worker to take the holiday, the worker's only allowed to carry forward 4 weeks if they're a normal worker. Whereas for atypical workers, because the two different types of leave aren't distinguished from each other, then an atypical worker is actually able to carry over up to the full 5.6 week entitlement. So the provisions are slightly more generous to them, and that's something you'll need to be aware of if you're operating carryover in relation to two different categories of worker. And then the final area covered by the new rules is in relation to rolled up holiday pay. And I think that's one of the areas that's going to be of most interest to a lot of employers. And in fact, we're certainly aware that a lot of employers have been operating rolled up holiday pay for a long time, notwithstanding the fact that it hasn't been lawful until the new rules came into force. So what is rolled up holiday pay? So it's the practice where rather than paying annual leave as and when a worker takes that leave, the employer instead includes an enhancement in each and every payslip that the worker receives to account for what is known as rolled up holiday pay. So as it says on the slide, if you were wanting to pay rolled up holiday pay to your worker, you would need to calculate 12.07% of the worker's total pay in their payslip and pay that as an additional amount or an uplift as part of their salary, but you would need to set it out as a separate amount on the payslip so it's clear what it relates to. And as I say, that's paid as and when the holiday is accrued rather than when the leave is taken. The exception to that is where, again, if the worker is on sick leave or family leave, rather than calculating it as a percentage of total pay, it's calculated as a percentage of pay over the 52-week reference period. But what it does is it makes it, in some cases, much more straightforward for employers to calculate how much they should be paying for holiday pay to a worker where they're, particularly where their hours vary from month to month or week to week. So what are the considerations that an employer will be looking at in determining whether or not to choose the option of rolled up holiday pay? I mean, as I say, a lot of employers are operating a system of rolled up holiday pay already, simply because it can otherwise be very complicated to work out holiday pay for atypical workers. So it presents a convenient and easy way to calculate holiday pay entitlement, and it can really simplify the calculations that you have to carry out, which can lessen the burden on your payroll systems. As I've mentioned, though, all of these rules apply to atypical workers only, so irregular hours workers and part-year workers. So it's not going to be something that you can apply to the workforce as a whole and expect it to be considered lawful. There's also the possibility that it might put workers off taking their holiday, because if they're working less in any particular month because they're taking holiday, that will have a reductive effect on the amount that they receive in their pay slip. So it may not be particularly welcomed by some workers. And in some cases, it may be that you as an employer end up paying slightly more by way of the rolled up holiday pay calculation than you would if you calculated it in line with the usual principles. So I've just put a few action points there on the slide for employers to consider in relation to the new rules. The first step will be to consider whether you do have workers which satisfy the definition of irregular hours workers or part-year workers, taking advice if there are some which seem to potentially fit within those categories, but it's not immediately clear. You can then consider whether you do want to move to a system of rolled up holiday pay for those workers. That's likely to require some discussion with the relevant workers, and also looking at the contracts of employment to see whether they need to be amended to accommodate for that change. And then it'll be a case of having relevant systems in place to ensure for appropriate compliance with the new rules. So to finish off now, Emma is going to look at the period for which employees can claim.
Thanks, Abizola. Unpaid holiday claims are usually brought as unlawful deductions of wages claims, and this means that a worker can claim back in respect of a series of deductions, and the time limit only begins to run from the last deduction in the series. So rather than having to take a separate claim within 3 months of each underpayment, a worker can link a sequence of underpayments together and bring a single claim within 3 months of the last underpayment in the series. There was some debate over what impact a break in the series might have. So in 2015, in the Beer Scotland case, the Employment Appeal Tribunal said that a series would be broken by a gap of 3 months or more between successive underpayments. That decision was queried in a number of cases since, and the law has now been clarified in the case that I've highlighted there on the slide. So this is the case of Anu, which came out last year and which involved police officers in Northern Ireland. There were a number of issues specific to that jurisdiction, which I won't go into, but the key issue for the whole of the UK was how the series of deductions should be interpreted. The Supreme Court said in Anu that a break of 3 months or more does not break the chain. And instead, whether underpayments form a series or not will be for a tribunal to decide in each case based on various factors. So each case will be fact specific. This will potentially make it easier for workers to make historic claims where they've not been paid holiday correctly. In Great Britain, the law was changed so that you can only go back and recover underpaid holiday pay and other wages for 2 years. This is known as the 2-year backstop. So the financial impact of this ruling for employers will be less significant here than it will be in Northern Ireland, where they don't have that 2-year backstop. I think the police officers in Anu can probably claim back to the start of their employment. So the final bill there could be more than £30 million. However, we're not expecting the number of new claims to be that big here, partly because most employers have already changed their holiday pay calculations to reflect the case law a number of years ago, and many claims would be out of time by now anyway. It's also worth noting that the 2-year backstop doesn't apply to a claim for accrued holiday pay on termination. So this would include holiday entitlement carried forward from previous years, and typically arises where a worker has been miscategorised as self-employed and so not allowed any holiday or holiday pay during the course of their engagement. So that brings us to the end of our slides. We have just got a few minutes to pick up on some of your questions in the Q&A box.
So I'd be happy to take one in relation to atypical workers. So the question is, if we pay rolled up holiday pay in the way that I described earlier, do we need to somehow log when the person takes annual leave to make sure that they take it? And that's a really good question. And I think it's one of the areas that can be can feel slightly artificial about rolled up holiday pay. And certainly before the practice of rolled up holiday pay became lawful, it was always advised that if you are going to roll up holiday pay, you need to make sure that there's a record as to when the worker actually takes their leave, so it can be shown that they're not being deprived of the opportunity to do that. The new guidance does seem to operate that it is still expected that workers will take their leave. So rolled up holiday pay isn't to be done in place of workers actually taking their leave. It's just a mechanism for paying it. In reality, I think quite often it's the case that if you've got irregular hours workers, it might be that they're working in such a way that it's quite obvious that there are periods when they're not at work, such that you might designate periods as sort of designated leave. Some employers do require atypical workers to still book their leave so that you've got a record on the system as to when they could be said to be taking it. But I think the practice differs from organisation to organisation. So strictly speaking, ideally you would log when the worker takes their leave, but I appreciate that in some circumstances that might not feel like the most practical or appropriate thing to do.
Okay, I think there's a couple of questions here on accrual of leave. So one question that we've got is, can holiday accrued during maternity leave be paid upon the employee returning to work? There's a general prohibition in the working time regulations against paying in lieu of leave, except upon termination. So if someone's just returning to work and their employment isn't being terminated, then you wouldn't be able to pay in lieu of that, and that hasn't changed under the reforms. Also a question here about, is long-term sick leave defined? So, you know, what do we refer to when we're talking about accrual during periods of long-term sick leave? Well, actually, under the new regulations, it isn't defined. So it's actually referred to as taking a period of sick leave in any leave year where a worker is unable to take some or all of their annual leave that they're entitled to. So in theory, you can see how if someone had leave booked right towards the end of the holiday leave year and take just a short period of sick leave, that might mean that they're then prevented from taking their leave during that relevant leave year, and they might be entitled to carry that forward. So no, that in short, there isn't a definition of that. The reason I've referred to long-term sick leave is because that's the most common scenario where someone's prevented from taking their leave during the year. If someone's just taking short-term sickness absence, then generally they'll be able to use their holiday leave up around those periods.
And then there was another question in relation to atypical workers. I'm just scrolling to find it. So actually just another question on accrual before I come to that. So do teachers and other school staff accrue leave if off sick or on family leave? The answer to that is yes. And again, that's an area where the new rules haven't changed anything. A worker continues to accrue an entitlement to statutory leave effectively whenever they're under contract. And that would remain the case if they're on sick or family leave. And then the other question that I was going to pick up. Yes, so if someone works 3 days a week plus overtime, are they an atypical worker? And that will really depend on what the contractual arrangements are. So if they work a set 3 days per week, the number of hours that they work on those 3 days don't change. And in terms of any overtime, that's a guaranteed amount of overtime, so it's a set amount is just paid at a different rate, for example, then they're likely not to be an atypical worker. In contrast, if the number of hours that they work per week is mostly or wholly variable and they're required to work the overtime under the contract, then they may be an atypical worker. So there's not a set working pattern that necessarily falls within those definitions. It will just depend on a case-by-case basis what the contract requires from them, and whether that is mostly or wholly variable.
I think we're just coming up to past now. If some of you need to drop off, that's fine. Abizola, I think you and I have a few more minutes to pick up a couple more questions for anyone who's able to stay on. But do feel free to drop off if you need to, because I'm conscious that we said we had half an hour. I'm just picking up on a couple of other questions here. So a question around the backstop. Does the 2-year backstop rule apply where employees have not been given the correct leave entitlement going back 10 years? And this is not for an atypical worker. I think the answer to that is it depends upon how the claim is brought. So if it's brought as an unlawful deductions from wages claim, there will be a 2-year backstop. But one way in which workers have been getting around that is by bringing a claim upon termination. And at that point, if they've been prevented from taking their leave, even over a number of years, extending back beyond the 2 years, then they can say that that's payable upon termination. So the right effectively crystallises upon termination. So there is a way around that backstop, but it very much depends how the claim is brought. Also, if someone is absent from work on a long-term basis, should they be paid their accrued annual leave if they request this? In short, yes, people can take holiday even though they're off, say, on long-term sickness, so they can request certain periods and take their holiday in the usual way during periods whilst they're off, and that might be a good way to manage it. Don't know if there are any other questions.
Yeah, there's one here that's worth clarifying, because I think it's quite an important one. So someone's asked that where we refer to workers, do we mean employees or workers? And yes, so it's workers that are within the scope of the legislation that we're talking about. So you'll know that there are, of course, different categories of employment status, all employees being workers, but not all workers being employees. But the rules in relation to holiday apply to all workers. So they may be a casual worker, for example, 0 hours worker, but the rules would still apply to them, even if they're a normal worker, so they don't work in an atypical way. Again, they would only need to have worker status to come within the scope of the new rules. And then the other one that I just wanted to pick up is around the 12.07% figure that I've referred to. So someone said that many NHS trusts do not pay their term time only staff 12.07% for their annual leave, but instead include the full leave entitlement in the calculation of pay. Is this not correct? So if I've got that right, I think what you're saying is that the figure that you use is a higher figure because that's intended to capture all contractual entitlement as well as statutory entitlement, and that's absolutely fine. So when we talk about 12.07%, that's obviously the minimum statutory holiday entitlement. Many employers will pay in excess of this, both in terms of holiday entitlement and paid holiday entitlement, and that's absolutely fine. You just need to use a figure that's representative of what it is that you're seeking to give the equivalent of, and the government guidance is quite helpful in allowing you to calculate that.
We've got another one here around, so I mentioned there's the grey area around what's included in normal pay, and one of the areas where we haven't got total clarity at present is around bonuses and allowances. So there's a question around, would performance and attendance bonuses paid monthly be included where KPIs have been met? Would that be included in the 4 weeks normal holiday pay? And I think the answer to that is yes, potentially, because that would potentially relate to payments intrinsically linked to the performance of tasks which are workers contractually required to carry out. Generally speaking, where bonuses relate to individual performance, they probably would be within the scope of what needs to be included. Where bonuses relate to, say, company performance or overall profit, then they probably don't need to be included. It's also worth looking, if you're saying that this is paid monthly, if it doesn't fluctuate in months when someone's on annual leave, then you wouldn't want to double count it. So it may be then that it doesn't need to be included because they're already receiving it, whether or not they're on leave in a particular month.
There's a question here as to whether this applies to companies that have an April to March annual leave year. So yes, the new rules in relation to atypical working apply to holiday years on or after the 1st of April this year. So yes, if your holiday year starts on the 1st of April, then it will apply. If it starts on the 31st of March, then it won't until next year.
Okay, I think unless there's any others from your side, Abizola.
No, I'm conscious that we've gone a little bit over. So thank you for those of you that have stayed for questions. They've all been really interesting. Just before I flag our contact details in case you need to get in touch with us, I just wanted to flag a couple of other webinars that we've got coming up. So the next one we've got is on managing sickness absence, and that's on the 17th of July. And then the one after that is on navigating statutory leave on the 24th of September. And you should be able to sign up to both of those on the website. If there's anything else that any of you would like to contact us about, whether in relation to holiday or otherwise, Emma and I would be delighted to hear from you. We really hope that you found this session useful and interesting this morning, and thank you very much for joining us.
And please do fill out your feedback forms when they pop up now on your screens.
Yes,
thanks everyone.
really helpful. Thank you.
Thank you.